So number 7, New York bus operators compensation versus American home
Judge,
insurance.
may I just have a minute to rearrange my notes?
You can have a minute to rearrange your notes. This is number 8. Thank you. So wait until your colleagues sit down. You may proceed.
For the record, Your Honor, Anthony V. Barbiero, representing New York Bus Operators Compensation Trust.
So given the years of discovery that have already taken place, how have the defendants been prejudiced by the delay in moving to amend the complaint?
Discovery in this case began and was supposed to end in September of 2019. In July of 2019, 2 days after the main witness for AIG was deposed, 180,000, I'm sorry, 118,000 pages of discovery just appeared. And without regard, I'm not going to belabor the back and forth, but certainly it was never stated to the plaintiff's then counsel that 118,000 pages of discovery was going to come down after this deposition. They said that there was some discovery that they had not been able to get together so that it couldn't have been produced before the deposition date. And counsel elected to go forward with the deposition, only to find that there were countless documents that indicated that there was a conspiracy between Arthur J. Gallagher and Gallagher Bassett to go, in Arthur J. Gallagher's contract, it goes totally outside their contractual obligation. They have a relationship, they got together, it's documented in the emails, they got together, and they decided not to tell New York Bus Operators Compensation Trust that their claim had been denied.
So let me ask you this. Even if
Judge, may I just finish? They didn't just do that. They condoned the continuation of creating and filing false documents saying that the claim was in coverage. So your question was, what prejudice is there because discovery was supposed to be closed in September of 2019? The only reason for the delay after September of 2019 was, number one, Gallagher Bassett could not produce the full version of their contract. They left out the most important part, the service instructions, for the very beginning of the term, when it was crucial that they act appropriately with regard to this claim and report it earlier than February 27th. Should have been reported about 3 months after they were took over.
So can I ask you a question now?
Yes.
Okay, so even after the 2019 document dump, the trust waited nearly 2 years before moving to amend the complaint. Has the trust offered a reasonable excuse for that delay?
I think the most reasonable excuse is that the amended complaint was filed based on the very same claims that were filed in the original, that were part of the original complaint, where the court said, but you can't do this because you're pleading the same damages. This is duplicative. Well, when you look at this, those allegations that were made in the complaint also support faithless agent.
So I'm going to ask
Now-
you about, I'm going to ask you about that.
Okay.
Because the Supreme Court concluded that the trust can't rely on the faithless agent doctrine because there's no agency relationship. Since the relevant contracts clearly state the defendants were an independent contractor, why was that an error?
Well, our briefs make it very clear that the law of New York is that designation of an independent contractor is not determinative. What's determinative is what did they do? Okay, well, what they did was they assumed complete control between the group administrator and the third-party administrator. They assumed complete control of the claims process. New York Bus Operators Compensation Trust got nothing from the employees. They got reports at claims meetings from these people who are now suing. And in those meetings, can you imagine the meetings that took place after 2014 where they sat with New York Bus Operators Compensation Trust and didn't tell them that one of their claims was not being covered, had been denied since 2012, and you have a problem? So,
Counsel, can I just ask you, because I want to kind of
yes, Judge.
piggyback, excuse me, on what Justice Chambers said. When I looked at this, I thought to myself, there should be a way to get some life into the contractual indemnification claim, right? That was the thing that jumped out at me. But I'm struggling with it in light of that 2.5 year time lag. So help me understand that.
The 2.5 year time lag was the time that it took for incoming counsel to digest that new discovery in the fashion that it was produced. And there was no prejudice because the claim, there's no new claim that was presented. There were no new facts that were presented, other than the facts that they well knew. Yes, the faithless agent.
Counsel, I'm sorry. I mean, you were adding punitive damages as among other items, correct?
Well, if the court, yes, the faithless agent claim would support punitive damages. But the faithlessness of their agency was disclosed to them in the complaint, and the continued, the egregious faithless agency, the criminal activity that was pled in the faithless agent complaint was well known to them. The only thing they didn't know is that we were going to actually make the claim the way the court said it should have been made and separate the damages from contractual damages to extra contractual damages. So I don't see how they were prejudiced by the delay.
So, counsel, help me understand this too. So there's this meeting in August of 2016, right?
Yes.
When your client learns about the denial. But then nothing happens for another.
That's not true. That's not true, Judge Ford. What happened was Lynn Cagnetta, the lead agent of Arthur J. Gallagher, who's sitting right here, was asked right at that table, Lynn, are you aware of this? And she said, absolutely not. So Lynn Cagnetta and AJG were put in charge of fixing the problem. Now, you can imagine what a great job they did. So that led to a delay until she was deposed in 2019 and finally admitted what nobody knew until 2019, that Arthur J. Gallagher, through Lynn Cagnetta, cooperated in this criminal activity, hiding the denial of the claim and condoning false reporting by GBS. And so I wouldn't say nothing was done. I would say that nothing was properly done because the wrong person was in charge.
Okay, thank you. We have
Thank you,
your
Your Honor.
argument.
Good morning, Your Honor. Samuel Thomas of Thomas Cady, and on behalf of the Arthur J. Gallagher and Gallagher Bassett companies in this case. I'd just like to take a couple minutes to address the two questions that have come up. One,
But I want to ask you a specific question.
of course, yes, of course.
Okay. The trust is contends that the existence of a principal-agent relationship is a question of law, of fact, excuse me. Um, why is that incorrect?
Well, the case law that we cite in our brief, and I wish I had a citation for you right off the top of my head, Your Honor, but the case law that we cite in our brief clearly says that where a relationship is defined by contract, agency would only come if the contract specifically says it's an agency relationship. These contracts all expressly describe the relationship as an independent contractor relationship. I think that would be the most direct question to or answer to your question, Your Honor. And on top of that, counsel even undermined the whole agency concept to begin with by saying that they handed off complete control to our clients. Agency is where the principal has control and controls the agent. Here, they're acknowledging that they weren't exercising any control over the alleged agent. Clearly, we were an independent contractor doing our job. I'd also like to mention, just to clear the record, this concept of a document dumped, and when Your Honor even used the word document dump, it kind of sends a shiver up my spine because I was directly
it's just
involved.
my way of describing.
I understand it's fine. I'm not criticizing Your Honor. I'm just
Right.
saying it's been a point
Well,
of
not in here when
it's
you
been a
get
it's been a
outside.
it's been a point of great contention in the case because I was directly involved, unlike counsel sitting to my left. What happened was, days leading into the deposition of Lynn Cagnetta, who was one of the principal people from Arthur J. Gallagher, we had a lot of documents, as he mentioned, 118,000 pages of documents that we've been scrambling to review that entire time. We notified Anderson Kill, the attorneys at the time, the partners. There was 2 partners and I think 1 associate at the time. We notified them that we had these documents, and if they wanted to delay all of the depositions, they were free to do so. We would be very cooperative in doing that. They chose not to do it. As soon as they had finished that deposition, the documents were produced a couple days later. Anderson Kill didn't call me up and say there was a problem. There was no complaints. There was no anything. There was no objections. There was no motions to retake the deposition. There was nothing. No objection of any kind whatsoever. 3 or 4 days later, they took our other 2 corporate witnesses, the actual corporate designees. One was Ed Lehan, and a couple days later was Aaron Ronaldo. And in both of those depositions, even though it had only been a few days, Anderson Kill used multiple exhibits from those productions for those depositions. So it wasn't some big mystery. And then after that, once the record closed in August of 2019 at Justice Emerson's order, they went on and eventually Anderson Kill filed the first motion to amend in November of 2019 after they'd had the documents for about 4 months. And they filed against the network adjuster company, but no amendment against us. They could have filed an amendment or tried to file an amendment at that point in time, but they were unable to. Or strike that. They chose not to. They could have, but they chose not to. And then, that same period of time, that 4 months, is about the same amount of time when new attorneys show up and say they needed 4 months. They took 4 months to now try to figure out exactly what Anderson Kill had 4 months to do. So 2.5 years later, we have a new motion to amend after the parties went through 12 depositions, as mentioned, hundreds of thousands of pages produced in discovery, untold number of motions, and as Your Honors can see, multiple actions related to this case. So the prejudice is palpable to our client when they try to now seek to file a motion to amend, not just to add new causes of action or replead previously dismissed causes of actions which were never appealed at the initial dismissal, but now they wanted to add 5 new individual defendants, being, these claim adjusters, these folks that, are doing this for a living and going home at 5 o'clock every day. They wanted to add all these people as now defendants, new defendants, and new causes of action. So the prejudice would have been palpable. We would have had to have litigated the case from the very beginning.
Okay.
Is there anything else I can answer for Your Honors?
That's it.
Thank you very much.
Thank you.
Good morning, Your Honors. Gregory Dennison for Defendant Risk Management Planning Group. I would just simply echo what Mr. Thomas just mentioned to you. And if you have certainly you have any questions, I'm happy to answer them. But the court already it below already answered the question of whether or not there was an agency relationship. They did so in the beginning, based upon the pleadings and the documents. They found none. When the trust made a motion to file the second amended complaint, they had the benefit of all this discovery, the 118,000 pages, the 12 depositions, all of that. They added nothing new with respect to either my client or the Gallagher defendants regarding the agency relationship. Mr. Thomas mentioned the lack of control. But they did not exercise any control over the TPAs. There's no special circumstances giving rise to a fiduciary relationship. The fraud allegations are almost word for word identical. They just threw in a couple adjectives like criminal. And there's nothing in the record to support these allegations, and the judge below was perfectly within her discretion to deny